You're all very welcome to this Law Society Practice Support information session. Today we're going to be discussing with Catherine MacGinley and Wesley Hudson a guide to good professional conduct, conflicts of interest. So over to you guys, and if we'll take questions on the chat as we go along, and if anybody has a question, we'll deal with it when it's fit. So.
Thanks, Justin. Wesley Hudson here. As Justin's just outlined, we're here to discuss conflicts of interest, in particular questions to ask yourself, which will help you determine if you're conflicted. So what I intend to do is go over, do an overview of the guidance, the current guidance, and then Catherine is going to deal with some scenarios at the end. So I hope you find it helpful. I am conscious that it's a short session, so I'm going to press on. So conflicts of interest. So what is a conflict of interest? A conflict of interest means a situation where a solicitor's separate duty to act in the best interests of one or more clients in relation to the same or related matter conflict. So conflict of interest may arise between a solicitor and clients and between two or more clients, where it could arise in circumstances where either client could take exception with what the solicitor has been instructed to do. It's predicated on the solicitor's principles of breach of duty of undivided loyalty owed to each client to make full disclosure to each client in a particular matter, or a breach of duty of confidentiality. It's predicated on a judgment-based approach by the solicitor to determine whether she or he could act, and not a matter, clearly not a matter for a client to determine. Therefore, careful thought by the solicitor to determine whether they can discharge the professional obligations to any particular client. Therefore, any risk should be identified, considered and mitigated at a very early stage. It arises from the relationship of principal and agent between the solicitor and the client, the solicitor being an agent of the client. So in practical terms, a solicitor needs to be careful, therefore, not to accept information that is to be kept confidential from a client. And its duty, and the solicitor, as we know, is duty bound to disclose all relevant information. Conflicts of interest between two clients. So what is this? Where a solicitor acting with ordinary care would give different advice to different clients regarding the same matter, a clear conflict of interest arises, and the solicitor should clearly not act for both clients. The solicitor owes a duty to both clients and must act in each of their best interests. And this can arise even where both clients may have the same or substantially the same common objective. Where differing advice is provided to each client, a conflict may arise. And as I referenced in the first slide, a conflict of interest may involve a solicitor being involved in a breach of duty of undivided loyalty owed to each client, a breach of duty to make full disclosure to each client, and a breach of the duty of confidentiality owed to each client. In anticipation of this session, both Catherine and I have consulted with the Law Society in relation to the nature of the queries that arise relating to conflicts, and the vast majority of the last number of years have related to property transactions. So we felt it important to delve into this a little bit.
Sorry, Wesley, would you mind putting the screen on full, like a slideshow?
Yeah.
You know how to do that?
I do. Yeah.
Off to the left, just there's the button on the left. Way over on the left, yeah. Just up, yeah. Right, yeah.
Sorry,
it's just the writing is quite small in it.
Is it okay? Yeah. So let me just. This one here, just
if you click on that one, that should do it for you. And that's it.
Now, do you see that?
Yeah, so you just scroll on one or two there, and
I'll get it. Yeah. Okay, so I was discussing a conveyancing transaction as as I was noting, the majority of the queries to the Law Society have in fact related to property transactions and where conflicts may arise. So a solicitor, as we all know, may not act for both the vendor and purchaser in relation to a property transaction. There are certain limited exceptions: a transfer of a family home, shared home to the joint tenancy of the owner and their spouses, transfer between associated companies and trusts, transfers between certain qualified parties, which is subject to certain statutory requirements and guidance by the Law Society of Ireland. And the following is a non-exhaustive list of examples in this area. A voluntary transaction, subject to the above exceptions, a solicitor cannot act for both parties in a voluntary property transaction. A solicitor firm cannot act for an owner's management company and a developer. Solicitors are prohibited from acting on behalf of both a borrower and a lender in a commercial property transaction. Solicitors may not act on behalf of all of the following: the lender and the borrower, the lender and the guarantor, the lender and the indemnified, the lender and the security provider. It is also noteworthy that the certificate of title system in residential mortgage lending is expressly based upon the premise that the borrower's solicitor does not act for the lending institution. In relation to non-conveyancing transactions, where clients consent to the same firm acting for both parties, the law requires that each client give informed consent. As we all should know, each client must know and understand that there is a potential conflict and must understand that the solicitor cannot advise each client fully. Therefore, caution is advised when acting for both clients, even on consent, as there are fiduciary duties arising by law and the relationship is predicated on one of trust, as we know. Where a solicitor has previously acted for both parties jointly who are now opposing one another, the solicitor should consider whether, based on the facts, there is the potential for a conflict of interest, as this may give an unfair advantage owing to certain information acquired. Consideration should therefore be given as to obtaining confirmation that the other party has no objection to you acting. Therefore, if the solicitor feels compromised on all the facts available, consideration should be given to advising the client as to instructing a different. It's largely on a case-by-case basis, and it's important to take clear instructions as to the scope of the instructed work, and all parties are clear. In relation to vulnerable clients, a solicitor should clearly not act for both sides in circumstances where it's believed that one of the parties is a vulnerable party. This is to ensure integrity of the transaction and to ensure independent legal advice is obtained. Characteristics of vulnerability are non-exhaustive, and they may include age, infirmity, mental illness, mental incapacity, physical disability. And we'll all be familiar with the Assisted Decision-Making Act, which introduced a new statutory framework for individuals who have difficulty in making decisions without help, and also the enactment of the DSS, which is topical at the moment. So some further areas and some further categories that where conflicts apply. State solicitors are prohibited from acting under contract that conflict with their duties to the DPP. Even where it is determined in non-property transactions that it's unnecessary for both parties to have separate representation, it may be prudent that independent legal advice is obtained by one or both of the parties as to certain elements of the matter. Independent legal advice can clearly only be provided by a different firm and not within the same firm. It is recommended where a second firm is engaged that they should witness any documentation. In relation to probate matters, a solicitor is not prohibited from acting on behalf of the LPR and a beneficiary and a person who benefits from an assent. A disclaimer, however, is recommended to be acquired from a beneficiary. However, caution as always, and consideration should also be given to the necessity of independent legal advice. In relation to family law, where a solicitor has previously acted for both parties in a non-contentious matter, and circumstances arise where one party returns seeking to instruct in a family law matter, the solicitor should assess whether they are in possession of information which will provide an unfair advantage, or certainly a perception of an unfair advantage. The solicitor should consider the facts as to whether they should act in this circumstance, and consideration should be given at the outset to obtaining confirmations that the other party has no reasonable objection. In relation to further categories of conflict of interest between solicitor and client, as we know, a solicitor should not act where there is a conflict or a potential conflict between the client's interests and their own personal interests in any given matter. Careful consideration should be given to the client's position. In relation to bequests by clients to solicitors, staff, or their family members, where a client intends to bequeath under will or make a gift by way of deed to the benefit of a solicitor or staff or their family, then a solicitor should not act and advise the client to instruct another firm. It is, however, not considered unprofessional for a token gift to be made to a solicitor, staff, or family member. In relation to wills for parents, where a solicitor prepares a will for their parents, this may give rise to a conflict of interest as it relates to the solicitor and the other family members. Consideration should therefore be given to the parent to instruct a different firm, and the same consideration should be provided to other family members. In relation to borrowing money from a client, a solicitor should not borrow money from a client unless that client is independently represented by another firm. An exception may arise where the client is in the business of money lending or the client is a lending institution. However, any such arrangement should be fully documented evidence and recorded on the client's file. In relation to loans to clients, if a solicitor lends money to a client which is a purely personal nature, documentation should be put in place to evidence that the loan is a purely personal one. And where security arises, separate independent legal advice is of course required. In relation to loans between clients, any such loan between one client to another client of a solicitor or firm should not involve the solicitor concerned whatsoever, and should ensure that no monies are paid out from one client ledger to another client ledger concerning a private loan between clients. Separately, a solicitor should not make or offer to make payment on behalf of a client as an inducement to obtain instructions. It is, however, permissible that a solicitor can discharge outlays on behalf of a client relating to an associated client transaction on the client's instructions to do so. We're coming up to the end of my part of the session. So in relation to power of attorneys, a solicitor cannot benefit themselves or others while acting under a power of attorney, given its fiduciary nature and the relationship of principal and agent. Joint ventures between solicitor and client do arise. There is no specific rule prohibiting a joint venture between solicitor and client. However, care must be taken to avoid a conflict of interest, or indeed the potential of a conflict of interest. In relation to in-house and public sector solicitors, this is grounded on a relationship of employer and employee, and the solicitor has a duty to their employer first and foremost. Therefore, awareness as to the employer's internal code of conduct may specify certain conditions which the solicitor has to be cognizant of. So where a conflict of interest may be identified, the solicitor should advise their employer make alternative arrangements in the circumstances. So that's largely it from me, Justin. I suppose just to summarize, there's myself and Catherine were speaking about this. In relation to property transactions, it's quite defined. What you can and can't do. Largely, you can't act for both sides, subject to certain limited exceptions. And then in relation to non-property transactions, it's not as defined, and it's based on the facts of the matter, the requirement for independent legal advice, and of course the judgment of the solicitor in any particular circumstance.
Yeah, so thank you very much, Wesley. So I think if we're going to take questions, I think we take them at the end and allow Catherine to have a run at it. I had one or two just small questions about this idea of representing two, or a solicitor representing two clients at the same time, as to how it sounds initially good in theory, but then once the thing starts to develop problems. So maybe we might return to that. And then the idea of giving loans to clients, and would you charge an interest rate? So if anyone wants to ask a question, we'll take it on the chat, but we'll hand it over to Catherine, and maybe she'll answer all our questions for us.
Probably not, Justin, but I'm going to try my best. Thanks very much, Wesley. And I think from what Wesley has said, you can see some of the difficulties sometimes that we have as a committee when queries arise, because it all seems very clear when you put it out in black and white, and maybe when you look at the guide to professional conduct. But actually, when it comes to a real life situation, sometimes it doesn't seem quite so clear. So we thought it might be helpful to give you some examples of actual real life questions that have been put to us in what we, I suppose, describe as our helpline. And you may or may not, I suppose, be aware that we invite colleagues to contact the committee if they have a situation which they consider to be difficult, and that can be done through our committee secretary. So in terms of queries which have come to us, the first example I want to talk to you about, and just to say we've changed the details here for confidentiality, but these are still real situations. Mrs. Murphy, an elderly lady, transferred a site to her daughter Jacinta about 20 years ago, and Jacinta and her husband Derek proceeded to build a house on that site, and they continue to live there now with their almost grown-up children. Derek has recently retired as the Garda Sergeant, and having a bit of time on his hands has been looking at landdirect.ie and has discovered that the maps seem to be somewhat different online to what he knows to be the situation on the ground. And he has come to his solicitor about that, and it transpires that a rectification is required. The solicitor concerned acted in the original transaction, and there's a bit of an undercurrent here which seems to be along the lines that Derek thinks that the solicitor should have spotted this at the time of the original transaction, notwithstanding the fact that it has always been very clear that they had no responsibility for mapping. But the solicitor is keen to try and help these people sort it out and wants to know if they can act on both sides. And unfortunately, I suppose our advice has to be that this is covered by the conveyancing regulations, which prevent solicitors acting on both sides, and independent representation is going to be required for one or other of these parties, notwithstanding the understandable desire, I suppose, to try and be helpful and resolve it for them. So there's a clear answer to that. Unfortunately, it has to be referred, or one side at least has to be referred elsewhere. So I suppose one of the other categories of query we quite often get relates to family law. And so an example that has arisen in that respect is a solicitor who's friendly socially with Brendan, who's in the middle of a hard-fought divorce with Sinead. Funnily enough, this solicitor somehow managed previously to act for Sinead in relation to an access application. And now Sinead wants her current solicitor to complain about the solicitor acting for Brendan in terms of conflict of interest and to make a complaint to the LSRA. And this solicitor has contacted our committee wanting to know what his answer might be to any such complaint. And I suppose this is maybe an example of how things can just run away with you if perhaps any detailed consideration isn't given to the question of conflict at the outset. This is an example of a situation which Wesley referred to when he was talking about family law, where if you're proposing to act in a situation like this, you have to give the other party an opportunity to object at the beginning. And if that had happened, then presumably that's what Sinead would have done and it wouldn't have got off the ground. But there is an obvious conflict here now, and the solicitor will have no option but to withdraw. And I suppose the difficulty at that stage is everybody's unhappy with him at that point. So ideally, it would have been something that would have been explored more comprehensively at the beginning. Another example relates again to a family law situation, but it's slightly different in that the solicitor has been consulted by a previous client, Claire, and her ex-husband, Finbar. And this relates to the sale of the former family home. Claire and Finbar are recently divorced, and two other firms represented them in that divorce. The court order spells out what's to happen to the proceeds of sale, and Claire wants you to act because she just has had enough of dealing with her divorce solicitor, who she sees as a family law specialist anyway, and doesn't want to go back to them in relation to this. Finbar has fallen out with his solicitors because the ensuing court order wasn't entirely what he was expecting. However, there is a very clear line as to what is to happen here. And there is potential for conflict, but I suppose we feel it could be managed in this case by advising both of them at the outset that you can only proceed on the basis that there's agreement between them and on the basis of the court order. And if a conflict emerges as the thing progresses, then you'll have to withdraw and not act for either of them. And if they're happy to proceed on that basis, then yes, it can be done. Another area which tends to cause issues in relation to conflict is administration of estates and succession. And in this example, you're instructed by Owen, who's one of 9 siblings of an intestate unmarried brother, Pat. And Pat also is childless. He died suddenly in a drowning accident, leaving a surprisingly large estate, which is made up mainly of his sole ownership of his data company. The total value of the net estate is expected to be just under 20 million euros. The majority of the remaining siblings want the eldest brother, Alex, to act as administrator, but one brother, Noel, objects. He eventually agrees that the administration can proceed if he is co-administrator, and you've agreed to act for them both on the basis that the distribution is governed by the provisions of the Succession Act 1965, and they both have a shared interest and not to mention a legal duty to ensure proper administration. However, Noel, as the thing has progressed, is now refusing to sign forms required for the purposes of the winding up of Pat's company. He says that he's entitled to what is in effect a redistributed share of their late mother's estate because she had lent money to Pat before his company took off, which he hadn't repaid by the date of his death. And Noel is saying he won't sign anything until Alex agrees that this, what he's describing as a loan, should be carved out of Pat's estate and paid to him. And the question is, what do you do? And again, this is a situation whereby you will hopefully have advised them at the beginning that you can only act where there is no conflict, and that an eye will have to be kept on the possibility of that developing. And if it does, then you'll have to withdraw. And this is unfortunately, again, a situation where if they cannot come to terms about this, then you will in fact have to withdraw and not act for either. So I hope those have, I suppose, maybe brought some of this a bit further to light, or maybe reminded you some examples you've come across in your own practice. But to the extent that Justin has any other specific queries, maybe now is the time to take them.
Yeah, so if anybody would like to ask a question, both Wesley and Catherine have very efficiently got us through the session in under 20 minutes, or just about 20 minutes. So there is time for questions and answers if you want to send them up on the chat. There's one there around, can you please go through the qualified parties exception when acting on a conveyancing transaction, if that makes sense.
You want to take that, Catherine?
I was going to say that was one for you, Wesley. Qualified part. I think I'm going to have to refer back to the guide for this. Let me just see here. Sorry, just 1 second.
That's okay. If I could encourage anyone out there who's listening to ask us a question, because we do have an extra few minutes, and we have Wesley and Catherine here from the Guidance and Ethics Committee. So it'd be a good use of their time if you had any other queries that you'd like to ask them. So we'll just jump to that one there from Martin. So acting for one client and a third party in a property transaction, the third party then comes to you for a further unrelated transaction. Guidance, please.
I think that is one that was referred to in what Wesley had said earlier on. That's fine as long as it is entirely separate and you're not being asked to use any of the information that you have gathered in the first transaction to benefit the client in the next transaction who's unrelated, or who's not related to the person from whom you obtained that information. So you just, I think Martin's doing a clarification there. Sorry, I just missed it. It disappeared from my screen. But the position really is that you must adopt a position which allows you to fully represent whatever the relevant current client is, without being compromised by whatever you might have done before.
Okay, thank you. So do you want to return to Martin's question and then his clarification, and then if there's an answer, if not, we can jump on to another one, and maybe Wesley, you take this one, and Catherine, you. So multi-representation is ideal. How do you handle pushback on the issue of costs?
I think the question is intended to mean that is in the scenario whereby the solicitor is recommending that the various parties go to different solicitors, and how one deals with the cost aspect of that. So I suppose it's from a practical perspective, there's always going to be a bit of resistance there around the cost element. But at the end of the day, the solicitor has a duty, as we've well set out, from the various different principles. And I think that the issue of cost should not be the sort of paramount determining factor, I would have thought, in the circumstance. Okay.
There's then a query then with regards to the Guidance and Ethics Helpline, and how do you contact them? So they're contactable through the Secretary of the Guidance and Ethics Committee, and the number is 01672 4800. Now there may be a more direct line, but that will take you to the main switch in Blackhall Place, and they'll forward you to the Guidance and Ethics Committee. What I'll probably do is include that specific telephone number. And sorry, the contact is Eamon Maguire, is the Secretary to the Guidance and Ethics Committee. So Catherine, do you want to go back and just talk about Martin's query there? Or not, or do you want to take it offline? I don't want to put you in a spot now.
No, that's okay. That was one about the qualified parties, I think, wasn't it?
Yes, of which he was not one, is my understanding. So to clarify, I did not act for the third party who was separately represented. So acting for one client and a third party in a property transaction, the third party then comes to you for a further unrelated transaction.
Yeah, and well,
I think
I feel we've sort of dealt with that on the basis that that's fine, as long as they're not expecting you to use the information that you gleaned from the first transaction to their benefit in the next transaction. But it sounds as though those two transactions are in fact completely separate. So there's nothing to prevent you from effectively being introduced to someone who becomes a new client just because you've acted on the other side of a transaction from them. That happens to be how you met them. But if it's an entirely separate transaction, then that's fine. It's I suppose similar maybe to someone who takes instructions from somebody who they may have acted against in a litigation matter. There's no prohibition on that as long as it's not in relation to the same matter or a related matter.
Okay, Wesley, do you have anything further to add?
Well, I think there is, as Catherine was saying, like there is means of obviously getting consent that effectively there's no objection, and there's also conflict waivers which can be signed by clients or where there's multi-clients involved. So like there is obviously means of regularizing things, we'll say.
Okay, so just reading out then from Justine. So questions are available or set out in the guide in the chapter on conflict and ethics. Solicitors should ask to ascertain if conflict arises. So this is the Guidance on Ethics 4th edition that was recently launched, and there's a whole list of questions within chapter 1 that might help with this, with getting guidance initially, maybe before contacting the helpline. I think the helpline is a second base after maybe reading the booklet itself in the first instance.
Yes, we certainly encourage everyone to read it. Absolutely.
Yeah. So Wesley or Catherine, do you have any final kind of summarizing points from what we discussed today, or any further?
Well, I suppose the only thing I would add is that sometimes when we're discussing these things at our committee, we very often say if you think there's a conflict, there probably is, and quite often we're twisting and turning trying to find a way around a situation where there probably is a conflict because we want to act for our client. Maybe we have a long-standing relationship with them, we don't want to lose them, but if you believe that there is a conflict, or you need to start thinking about conflict, then you need to take that seriously, I suppose, and examine it properly, because it is something which I'm sure many people have experienced can just blow up and cause all sorts of problems later on. So it does need to be cleared off as early as possible.
Yes, I would with that. I think it's something that should be identified at a very early stage, so as to obviate any further unintended complications further down the road.
Okay, so I'm just adding just 2 links there to the chat if anybody's looking to go to the Guidance on Ethics web page, the About page, and then the actual booklet itself, the 4th edition. Is available on the first one as the PDF, so you should be able to get into them directly. You probably need a user login into the Law Society website, but you should all have one of them. So I suppose we're just coming to the end of the session. Unless anybody has a final question, I just bring up next in 2 weeks' time on the 28th of June, we're going to be talking tech, AI, and the future of ethics with Jennifer O'Sullivan. So that'll be the final one for the summer. We'll be back in September with a full schedule again. So hopefully you'll join us for that last one. And just unless you guys have anything further to say, I'd like to thank Wesley and Catherine for joining us today. So thanks very much. And I hope everyone will maybe go take a walk in the sunshine now. So thanks, everyone. We'll talk to you in 2 weeks' time. Thank you. Slán.
Thanks. Goodbye.
Bye. Thanks, guys.